respected participants, and all the other members of the seminar. Myself, Amjath AM, and along with my co-author KR Azad, will be dealing with religious conversion and freedom of religion in India. So, when we are dealing about religion, this is undoubtedly the most sensitive issue in the country, which has roots in all the possible aspects of a citizen in his personal life, in his social life, in his political life. So, how do we define religion in terms of our constitution and our laws, and how do we balance it out? That is one of the most fundamental questions of religion and constitution. So that is the reason why we have given the idea of we have developed the philosophy of secularism, and according to the words of Donald E. Smith, that is the Indian secularism is, which means that it is non-communal or non-sectarian, but it does not mean non-religious. It is not a separation of all a separation from the state and religion, but it is rather a non-preference doctrine. That is, it does not give any privilege to any particular religion, or in an idea of following a religion is respected. At the same time, it is not giving a particular preference to any particular religion. That is, state by itself, it will be non-religious, but it gives an inclusive idea. It gives an inclusive philosophy to for the accommodation of religious philosophies. So in the freedom of religion is enshrined under Article 25 and 28 of the Constitution of India. And the most important thing is that nowhere in the Constitution of India the word religion is defined, but the concept of religion is mainly developed through judicial pronouncements. So, to what extent the state can interfere? That's one question. So the thought process is always autonomous with an individual. The individual has complete freedom to think, and the freedom of conscience is inherently within him. So the state has no authority to go and interfere with the thought process of an individual, or he has no authority to interfere in the way how a person thinks. But more or less, it is the idea of uh, manifestation of a religion. That is where the state can actually the interfere. That is when a manifestation of a particular philosophy or a religion, a religious ideology becomes contrary with the public order, morality, health, and social order. Then the state has the power to dictate a citizen's thought and freedom of expression of his religious belief. So, with regard to conversion in the Indian legal context, the conversion is not given as a guaranteed right under the fundamental rights of the Indian Constitution, but in the Constitution and the judicial pronouncements in that time, that is in the 1954, with regard to the development of the Constitution, was not seeing the idea of religion as a negative impact or a negative way of seeing state, as that we see in the church and state separation in the Western countries, where the Western countries were kind of moving away from the idea of separation of the church and state, or even the idea of preserving the sacred ideologies of religion. India had a different vision to that. India had a vision of preserving the values of religion. That is held in the case of Ratilal Panachand Gandhi of the state of Bombay, held that the provisions of Article 25 has made that the provisions of Article 25 clearer by affirming that every person has a fundamental right under the Constitution of India not just to approve a religious belief, but in every reason in his judgment and conscience to exhibit belief overtly as sanctioned by his religion and propagate his religion. Propagation is also recognized, exhibition is also recognized, and for the edification of others. So the religion is seen as a positive, in a positive sense. And in Divya Darshan Rajendra versus State of Andhra Pradesh, the Supreme Court held that the right to propagation of religion means the right to communicate a person's belief or to expose the tenets of faith, but would not include the right to convert. So here conversion is not recognized, but propagation is recognized. That is, a positive propagation of religion for change of attitude or change of conscience or change of philosophy in a person's thought process is recognized. But conversion, he cannot use conversion. He cannot convert forcefully for one person to another faith. So why is this aspect of conversion not recognized? Because the word conversion has an element of force in it. But propagation is different from conversion, because propagation is just exposition of ideas. It's just an expression of or exhibition of what a person feels, right? But conversion is different. Conversion, once it comes to conversion, that is forceful conversion. There is a use of force in conversion. That is why conversion is not recognized. The reason that every person should have a freedom of conscience. Conscience is highly respected in the Indian Constitution, and the right to profess, practice, and propagate religion is also recognized. But along with profess, practice, and propagation, the fundamental root of this is because the Constitution believes that under Article 25, Clause 1, that the people should have a freedom of conscience by themselves. That is the reason why a forceful conversion, that is, a person, any idea that goes against the conscience of an individual, is not recognized. But any idea that goes in parallel or in along in conformity with a person's conscience, it should be recognized. And conscience refers to a man's personal sense of right and wrong. It could be religion, it could be atheism, it could be theism, whatever be the person's fundamental philosophy of viewing a life in the personal context, in the spiritual context. That is what is called the aspect of conscience, and it is basically for the conduciveness of his own spiritual.
Thank you, Amjit. So let me start about the topic anti-conversion laws. The Constitution of India provides for the freedom of conscience and free profession, practice and propagation of religion. The 42nd Amendment of the Constitution says India is a secular country and it has equal respect for all religions, but at the same time, India is not a religious state. It equally treats all religious groups, provides protection, freedom of practice, profess and propagate religion, and to manage religious affairs. This proves that the positive dimension of secularism. So what is religion? Religion has not been mentioned in the Constitution of India and it is not so easy to define. Swami Vivekananda once said that the end of all religions is the realizing that God in the soul. That is the one universal religion. So what is anti-conversion laws? The anti-conversion laws that have made on the country is to protect the person from converting or trying to convert a person from one religion to another by illegal means. The person who wanted to convert such people from other religions actually wanted to make the other religion sweep from the country, which will eventually make their religion a high standard and show that the religious enthusiasm within the respected country. As a country like India, where the spiritual practices have diverse effect and more believers, the laws will only protect the individual persons and not the entire country. Before independence, the princely states, many of the laws were operation in the anti-conversion of the people. Many of such states passed the legislation, and the Britishers were also propagating such religion which follows the Indians, and the Indians showed resistance to convert to the alien future. The conversion means the conversion secured by fraud, misrepresentation, coercion, intimidation, and undue influence, and such other types which will give severe punishment. Uh, and it also targets the minors as well as the members of the scheduled caste and scheduled tribes. Around 7 to 8 states of India has passed the anti-conversion laws. There are many states to enact the laws. Most of the people, mainly who support the anti-conversion laws, proclaim that these laws are made to prohibit conversion that is happening throughout the country by illegal means. The anti-conversion law strengthens social hierarchies by presenting those communities which are already socio-economic and disadvantaged. Even the law prohibits only possible conversions. Changing one's faith is a private decision, not a public act. We all know that what happened in 1956, where because of the social stigma present in the social hierarchy in the Hindu religious groups, there are mass conversion. Around 5 lakh Hindus of SCSTs converted to Buddhism. In the famous case of Dr. Rahim, Abdurrahim and Padma Abdurrahim, the Bombay High Court said that conversion to another religion basically requires change of faith. In the famous Sakti Vahini versus Union of India, the Ka Panchayat case, where the apex court ordered the state government uh, that any attempt of Ka Panchayat of any other assembly to prevent two consisting adults from marrying is absolutely illegal, and it laid down 20 remedial and punitive measures. In Muhammad Salim and Hamsuddin case, the original the marriage questions was whether the marriage between Hindu woman and Muslim was a regular or irregular. Supreme Court upheld the Kerala High Court order and said that it is neither valid or void, but is merely irregular. Any child born out of such wedlock is entitled to claim the share in the father's property. In Ratilal Anand Chandus Gandhi was a state of Bombay. The court held that freedom of conscience to the religion is belief in one's faith and is not merely for followers of one particular religion but extends to all. In Arun was a state of Bengal. The Supreme Court holds an attempt to raise communal passions through forcible conversion would be a breach of public order and affect the community at large. In Dilbar Habib Siddiqui was a state of UP. It said that Allahabad High Court said that non-Muslim bride must convert to Islam to marry a Muslim. Failing that matrimony of a Muslim man would be void and it would contradict Islam dicta and tends to the following Quran. Next is about the love jihad and garbapasi. What is love jihad? It is a love jihad is or it is also called Romeo jihad is another religious conversion that has sparked in the national attention over Muslim men targeting the non-Muslim women, converting them to Islam by falling in love. It was an alleged conversion in Kerala and Karnataka in 2009. Garbapasi is another serious conversion activities facilitated by some of the Hindu organizations facilitate conversion of Christians and Muslims to Hinduism and Sikhs. In Telangana, Andhra Pradesh, there are 8,000 people who were converted to Hinduism. In Tripura, in 2019, 96 tribal families converted back to Hinduism. In Kerala, 35 people converted back to Hinduism in 2015. In Gujarat, in 2020, 144 tribal group Christians converted back to Hinduism. And about love jihad, the famous case in 2018 that Shafin Jahan versus Ashokan in 2018 case where the apex court restored Hadia's marriage. 10 months after the Kerala High Court declared that the case was the marriage was. So coming to the conclusion, religion has developed alongside civilization over the ages as a part of human society, and where religions exist, the conversion of people also exists. Every person has his or her right to choose and follow whatever religion he or she wants. It's a religious freedom. No one has the right over the person than the person himself. What India needs today is a relationship between religion and its persons. While we do not negate the positions of the importance of genuine religious conversion and the conversion legislation needed for our country. Apart from the states that have implemented, those other states are also should enforce these laws because we see in our daily life due to many possible conversions are taking place in different parts of the country. We only know what comes through media. Anti-conversion legislations faces a significant challenge in both original framework and Indian culture and to the countries. Thank you all.